Makueni Senator Mutula Kilonzo Jr. has called for the establishment of alternative dispute resolution mechanisms at the county level. In an exclusive interview with Ebro Africa TV, the senator says the political crisis facing the county may have been resolved amicably under such a system. The fate of the Makueni County government now hangs in the balance after President Uhuru Kenyatta and the Council of Governors agreed to form a commission to investigate a petition filed by Makueni residents seeking to send the governor and MCAs home. The commission will, however, be appointed after the Independent Electoral and Boundaries Commission verifies the names of the over 50,000 residents who petitioned him over the dissolution of the county. Senator Kilonzo, just like the president, feels more consultations were necessary, while the residents and a section of the political class feel there is need for fresh elections.
Whilst the Council of Governors made that sort of pronouncement about attempting to resolve this matter, and whilst the statement that was issued yesterday suggests that there was a mechanism to try and resolve the issue, no such mechanism was employed, because as I have said, the Council of Governors did not call a meeting where all leaders would sit to give out the issues that would then form the basis of a dispute resolution mechanism. If they did, they only sat and listened to the governor. I would have thought that ideally they would sit with the council, with the Speaker of the County Assembly of Makueni. They would sit with the members, the various committees, to understand the issues, because as I've said, you can break down the issues into 3 or 4.
But what is at the heart of a dispute that could see the first county government since the entrenchment of a devolved system of governance dissolved?
It's just a question of how do we manage the county? What are the priorities between the county government and county assembly? And if these are the priorities, how do we carry this process forward? The legislation, which is the County Governments Act, assumes, quite rightly or wrongly, that the governor and even the constitution will prepare the plans. Those plans will be approved by a county assembly. Now, county assemblies are in the process abrogated themselves this right to become also managers. They have forgotten their work is to oversee.
The current law only establishes a framework for consultation and cooperation between the national and county governments and amongst county governments. It's meant to solve intergovernmental disputes.
In the case of Makueni and in the case of the County Governments Act, I've said this before, that there appears to be a lacuna in the law. The lacuna is that even if you had a dispute resolution mechanism, there is no legal process or legislation to back that. And therefore, it would be ad hoc. I would expect the Commission of Inquiry appointed in the case of Makueni to come up with proposals that the County Governments Act be amended to the extent that we should have a mediation committee to resolve matters over county before you get to the place where the Commission of Inquiry sits, so that then the Commission of Inquiry, in this particular case, the 2 people who are experts in conflict management will be able to establish whether in fact the mediation committee or the dispute resolution mechanism that was employed in the county before you go to the Commission of Inquiry followed the law.
Previous attempts by local and national leaders to solve the crisis facing the county failed.
We don't know